of the Wausau Ethics Board to order. Will the clerk please call the roll?
Dexter,
Here.
Hostler,
Here.
DeVos,
Here.
Kearns,
Here.
And welcome to all the members of the public and the press that are here as well. First item on our agenda is status of proceedings in the matter of the pending complaint against Mayor Doug Dinny. The board, at its last meeting on August 25th, granted the respondent's motion to dismiss only as to 18 U.S. Code Section 595. It denied the remainder of the respondent's motion to dismiss and denied the respondent's alternative motion in limine. At an earlier meeting, the board granted the respondent's motion to compel the city attorney and the city clerk to sit for depositions at a place and time agreeable to all parties. It also adopted a scheduling order with a deadline for pre-hearing motions being August 8th, and the deadline for completing discovery was Friday, August 29th, with the hearing in this matter scheduled for Friday, September 5th, which is the day after tomorrow. Just yesterday, the respondent filed documents that included a second motion to dismiss, or, in the alternative, motion to adjourn, and also a motion for reconsideration. Those documents also present legal arguments. Because these documents were filed with the clerk just yesterday, the board members have not yet had an opportunity to review them, and discussion or action on these pleadings is not on the agenda for this meeting. Nevertheless, the filing of those pleadings will have some effect on how we proceed. The next item on the agenda is consideration and possible action concerning the pre-hearing procedural matters, discovery, and subpoenas in the matter of the pending complaint against Mayor Doug Dinny. The respondent's filings received yesterday reflect that the respondent was unable to complete the depositions of the city attorney and the city clerk that he intended to conduct. The respondent served notices of depositions on the city clerk and the city attorney and has filed copies with the board. He was unable to conduct those depositions, having been told by the attorney that had represented the clerk and the city attorney that, quote, "I do not believe there is any scenario in which Bernardi and Jacobson will be appearing for depositions on Friday," that was August 29th. So that that attorney suggested to Attorney Erlinson to not plan on making the trip up to Wausau. So the depositions did not occur. Among the respondent's filings is a motion to dismiss, or in the alternative, a motion to adjourn the hearing. If the board were to adopt a motion to adjourn the hearing for a date that is later than September 5th, it seems possible that it could result in the respondent being able to complete depositions. I'm not suggesting it's probable, but it seems like that would be another opportunity. At this time, I guess I'd like to ask Attorney Erlinson to advise the board as to how much time he may need to complete depositions if the subjects are cooperative.
Well, thank you, Chairman Dexter. I can complete the depositions in a day. I've had an open invitation for the clerk and the city attorney to tell me what day works. They will not appear, and it's based on, ostensibly, on their view that they cannot show up and testify truthfully as to matters of historical fact without lawyers present. And they burned the budget that was afforded them on a motion to compel that, given the response that we got, which said, well, it's not really a privilege issue, and it was denied. Frankly, it was a groundless stance on whatever it was that was justifying them not appearing in the first place. And now they're out of money that was allocated by the Common Council. The rules that govern these proceedings are clear, and that is that Mayor Dinny is entitled to pre-hearing discovery as a matter of due process. We have done everything we can with that the rules contemplate, And absent a referral by this board to the Common Council to request that the district attorney bring a contempt proceeding, there's nothing else I can do.
Well,
And as the motions make clear.
Thank you for answering my question, which is how much time might you need if things were to go in a cooperative way? And, you know, if we try to be optimistic, I think we have to take into consideration whether the Common Council would authorize legal counsel, additional legal representation to advise the subjects about their obligation to appear for depositions. And if there are any questions that they should not answer, legal counsel, if legal counsel, further legal representation is appointed, could likely take into consideration that in order to compel the subjects to do so was issued by this board, and that the board expects their compliance. Legal counsel might also advise the subjects that in light of that order, continued refusal to cooperate might result in the board issuing an order to show cause why they should not be held in contempt of the ethics board. So it seems kind of key to determine if we might get some idea of when the Common Council might act on whether to authorize legal counsel to these subjects. That might help us get an idea of how much time might reasonably be needed to obtain cooperation from the subjects. And I'm wondering, I don't know. I know that there was this matter came before the Common Council, this idea of authorizing further legal representation. And from what I read about it, it sounded like there was going to be a special meeting held of the council to deal with this. And I'm wondering, Cody, are you aware of any plans for that special meeting?
I am not.
Any other members have any knowledge of any plans on the part of the Common Council?
I have not heard anything about a special meeting for a legal budget.
And I have the same information you had. There was a special meeting, but I never heard it. I never heard the meeting being called, coming to order.
I think it's important, though, that if these two individuals feel that they need legal representation in order to give a deposition, that we be respectful of that. I'm not in a position to tell them what they're, I'm not legally advising them in any direction. I don't think the committee could do that. So I think it's, I think it's imperative that they do have the representation that they need. I don't have any say in the matter of whether or not they'll get it, but it's my personal opinion.
Any thoughts, Robin?
I don't know if it's our prerogative, I guess, to ensure that they have legal counsel. But I don't know the process for the order to show cause either. If that needs to be on motion from the respondent to request us to do that, to request an order to show cause. I guess I'm just not sure I understand the procedure for that, but I don't necessarily know if it's in our wheelhouse or prerogative to worry about them obtaining attorneys.
Right, and I'm thinking that it would be helpful. It seems much more likely if they are represented that some of these legal considerations of non-cooperation would be discussed with that attorney, and it might change, what their response is to sitting for depositions, because I think that's pretty important. And maybe, we don't have any idea when that special meeting might be held, but maybe we just need to consider the possibility of adjourning the hearing for a long enough period of time that there should be some action or some outcome as to whether the Common Council will authorize further legal representation. And I think if they aren't represented, I'm not saying that should mean, oh, well, we just kind of forget about it. That's where.
Well, I guess I'm just thinking if there was an order to show cause hearing on the schedule, then it may prompt action quicker from the Common Council, potentially. To have some dates that everybody's working towards, that there is some sort of hope that those attorney fees, or that additional attorney fees would be approved. Otherwise, it's just sitting out there.
Well, I think that there is a need to adjourn the hearing simply because we've been presented with some pleadings that we haven't even had an opportunity to review yet. So, in order to act on those, there's a motion to dismiss and a motion for reconsideration, those kinds of things. It seems to me we have to adjourn the hearing for some period of time so that we can deal with that, and maybe in the meantime we can also determine talk about what we might do if there isn't cooperation by the time of the delayed, the adjourned hearing date. So we got a bunch of things going on here. And
I just wanted to,
Yeah.
Attorney Larson is asking to speak. He's
Sure.
got his hand up on the Teams meeting.
go ahead, Attorney Larson.
Thank you. Thank you. I was just going to kind of bring us back to where you started, and you sort of went there already, but I think the issue is we are set for a hearing on Friday. And we will have a hearing. This matter is going to have a hearing. I don't want anyone to think that we're somehow going to delay and delay. There will be a hearing. The question is whether it should be Friday. The respondent has said that he's filed these motions. And one caveat is if his motion for dismiss is granted, we won't have a hearing. That I don't mean to say that's off the table. That is a possible issue. But his alternative motion is to delay until those depositions are held. The legal framework is we have to have this in 30 days of deciding that there's going to be a hearing unless the respondent petitions for a later date. And so I think it falls back to the respondent to tell us, what are you asking? Because we need to set a different date. And what date should it be? Should it be Monday? Should it be Tuesday? What date should it be? Should it be a month?
Well, it's until Mayor Denny has the right to exercise his full discovery rights, including adverse examination of witnesses who will testify at the hearing. We've been trying to do that since April. There is no order to show cause procedure in Chapter 2.03. There just isn't. The rules of evidence apply, but the rules of civil procedure that might allow this board to act as a circuit court might are not incorporated. And so I think it's for counsel to the board to advise as to what enforcement powers,
But
if
that's
any,
not
this
the
board
issue.
exists.
With all due respect, we may cross that bridge when it comes to enforcement of our order to compel. And then we will face that question of can we issue an order to show cause? And what would be the impact of that? But that is not for today. For today is when are we going to hold the hearing?
Well, that's a God
date
question.
should we set? What date
There is
should
no
we
date.
set?
It's 30 days at least after we have a chance to take these depositions. Or 2 weeks. I just want the transcripts so that we're ready to go. But I can't give you a date because I don't know when the city clerk and the city attorney will deem it in their interest and the appropriate time to show up. I can't tell you that. How could
Members
I?
of the board, I would not defer to the witnesses or to the respondent the issue of whether we're going to hold a hearing. Because potentially they could continue not to show up, those depositions could not be held, and there would never be a hearing. I think we should set a date, and if that date is not met, we reconvene and we decide how to proceed with enforcement. Because I think we would have to face enforcement. We've issued an order that we followed. And if it's not, we should pursue enforcement. What manner that takes remains to be seen. But that's getting ahead of ourselves. We don't know whether those depositions might be Monday, in which case we could have the hearing shortly thereafter. So I think we should set a date. It should be a date that the respondent agrees to, because our code says the respondent makes the request to defer the date to a later date. It sounds like, he's, correct me if I'm wrong, Attorney Erlandson, but you've said you want 2 weeks after the depositions, and I think you said, so maybe a month from now. Did I hear that?
Well, what I said was 30 days after the depositions, but if we need to do it 2 weeks after the depositions, I'll do it. I just need time for the transcripts. So I did not say a month. I said I don't know when these people are going to permit themselves to be deposed. And from an enforcement standpoint, I don't see a procedure.
Is it fair to characterize your request as delaying a month to see whether those depositions are held and you get your transcript? And if that all pans out, we're going to have the hearing in a month.
With the caveat that if they don't, I'll have the same objection. And one of the motions that we filed yesterday, which was the first business day after Friday, which was the day they didn't show up, is a motion to dismiss, or in the alternative to adjourn. You can hold the hearing, but from Mayor Denny's standpoint as the respondent, if there is not discovery of those witnesses, their testimony and any hearsay statements or documents they've created should be excluded from the record.
Let me ask a question. So in the instance that these individuals don't provide evidence and they aren't present at the hearing, would that negate the deposition then? Just out of curiosity. Like if they were not, if they for some reason found the ability to deny their ability to have a deposition or to be present for the hearing, and we don't actually have any physical evidence from those individuals, does that change the prerogative of the respondent at that point, or?
No, I mean, any documents that Mayor Denny responded in response to the board's investigative demand that were either authored by or in which statements or actions attributed to either of those witnesses are referenced should be excluded as well, because they haven't been examined about it.
My issue kind of goes back to, the fact that we had a discovery deadline and Attorney Erlandson attempted to meet that discovery deadline. So it sort of puts us, for me, when you look at our orders that we've already submitted, what if we're adjourning the date for the discovery deadline, I feel like we're going to be back in the same square one where we are right now if they refuse to appear. And so I'm wondering how we don't end up at square one again with all of this, because it appears that they're not going to appear. I mean, it seems like they're not going to sit for depositions.
Well, that's a fair point. It seems certainly conceivable to me that we might wind up back at square one. But the thing that to me seems to make a difference is that there has been discussion at the Common Council level of providing them with legal representation. And I think if they get legal representation, they're going to be talking with their attorneys about what happens if they don't sit for the depositions.
With sufficient warning of whether we can do an order to
Show cause.
or if it's a contempt proceeding or something like that.
Exactly. And
Okay.
so I think it's worth another try. And in any event, we've got motions that have just been filed. And I certainly didn't mean to cast any aspersions on the respondent for not getting those out to us earlier because there wasn't time. Just that we haven't had time to even begin considering those motions. So, I mean, just to deal with that, unless the board would be prepared to dismiss everything right now, throw their hands up and say there's nothing we can do, then, but I think we have a duty as an ethics board to try and get a favorable outcome here in terms of the process, making it work. And it's been frustrating. I've expressed my frustration, and I think we all have, that there hasn't been the cooperation from those two potential witnesses. I know it must be extremely frustrating for Attorney Erlinson, but I think there's been some change in circumstances that makes it worthwhile to give it one more try. The optimum thing would be that they do testify at depositions and at the hearing. And I think Attorney Erlinson has mentioned that if that doesn't happen, and this is probably going to be the last attempt to make it happen. If that doesn't happen, then the Attorney Erlinson has stated his position on exclusion of anything that we might have received from those witnesses. So we do need to be, it's useful for us, I think, to spend some time trying to look forward a little bit, but the actual decision for us at this point is, are we going to have a hearing on Friday, or are we going to delay it so we've got time to consider motions, so we've got time to see what happens with the Common Council and providing representation to them. And one other thing that I haven't mentioned yet that would be beneficial giving us a little more time is, it's my understanding that Attorney Erlinson and Attorney Larson have worked out the content for an agreed statement of facts. It just hasn't been signed yet, and I'd like to see that taken care of before we get to a hearing as well, because that could have an effect on how much time we need to spend having witnesses testify about facts that nobody's really disputing. So I think actual scheduling is the next item on the agenda. We've spent some time talking about whether we should adjourn the hearing to some point, but the next item on the agenda is discussion of and possible action on scheduling any additional board meetings and/or rescheduling the hearing in the matter of the pending complaint against Mayor Doug Denny. And I think just to get a little more discussion going and get something on the table, I would move to adjourn the hearing to a date that we can pick that's about a month from now. It would require us to check our schedules, try and come up with a date. Somebody's going to need to second that motion if we're going to be able to vote on it. Should we look at schedules at this point?
I think in order to respect the request of Attorney Erlinson, we definitely have to consider that, and I think it's probably best if we do look at our schedules. So, and I think it's also important that in the event that we do it, if we do postpone the meeting, we could leverage Friday to be the next committee meeting day to discuss the documents that we received and have time to discuss.
That thought certainly occurred to me. However, I think that might be too soon for good analysis of the documents that we're going to have to be looking at. I think it certainly, I think, puts some additional pressure on our counsel, who would be advising us about those motions.
Having not seen them, I guess I wouldn't know if 2 days
Right.
or what have you.
Yeah, And it's logical to think we've got some time set aside, but it's just too soon, I think, to be dealing with that.
Chairman Dexter,
Yes?
I don't mean to interject into a committee discussion, but might I suggest that this discussion about what to do and what additional hearings might be necessary would probably be better informed on Saturday morning, or excuse me, Friday morning, the 5th, after everyone's at the very least had a chance to read what we submitted. Because if it doesn't have to be ruled upon on Friday, but any scheduling the board does might be informed by when it will be prepared to rule on those motions, and then any hearing that would follow. So
Attorney-
what I'm suggesting is that you may be scheduling not just a hearing date on the substantive evidentiary presentation, but also potentially a hearing on the motions that were filed when the board is prepared to issue decisions.
I'm curious, would it be a hearing on the motions or an Would that be a hearing on the motions or an action on them? I mean, it sounds to me, at least reading this, because I'm ignorant, thinking what has just been said is that what is suggesting is we not really have a hearing, but we have a meeting.
That's right.
That's why I read it, so it wouldn't be a hearing.
Right.
So we could decide today not to have a hearing, but just to have a meeting. And is that what Attorney Erlinson is asking? And that's fine. I just want to know.
Yeah.
That's-
To be clear, you're suggesting that we not reschedule the hearing date today, that we review what has been sent and then,
All right, but the motion is
Postpone- yeah,
act on
postpone.
that motion.
yeah, like we can
Right.
schedule a meeting
Yeah.
to meet to
I mean,
discuss
that would be another opportunity.
setting the
but,
date
yeah.
for the hearing. Is that what you're
Right.
suggesting?
Yeah, and a date where whatever decision is made, I mean, maybe you'll issue it in writing, or maybe you'd issue the decision or announce it at a hearing like this, which would be a separate hearing before the
Right.
evidentiary hearing.
Okay.
That's the point, is Friday could be used as a scheduling discussion, a meeting, and then you can decide how and when you want to do what you want to do in disposing of or ruling upon the motions that were filed yesterday.
Right.
And then at the same time, with that milestone in mind, schedule an evidentiary hearing.
And-
Or not, whatever we wanted to do.
Oh,
Yeah.
Well-
that'd be great.
Right.
Yeah,
Okay.
and
Fine.
even if we are not in a position to make rulings on the motions, we will, at least by that time, have had an opportunity, the members of the board will have had an opportunity to read through those motions and have a better understanding of what they're going to be dealing with. Attorney Larson, do you have any thoughts on that suggestion?
Well, do we know when this special meeting that has been referred to is going to happen at the council?
No,
Does the respondent know?
I have some connection on this issue. I believe it's on the Tuesday night council agenda. It relates to additional funding for Attorney Sam Hall.
That would be correct. It's on Tuesday's agenda.
thank you.
So I think that might provide another date to keep in mind that we might want to be after.
I didn't catch the last part of what you said, Attorney Larson.
Well, rather than hold our date on Friday, I wonder if we would want to get at least to Wednesday of next week so we know what happened at the council meeting
Okay.
before we meet next.
That sounds like good advice to me.
So if I understand, then the idea would be to to cancel the September 5th hearing and instead to act by, at least after next Wednesday, to respond to the complaint, the respondent's motion. Right, we would do
Right.
all that, all the things that Attorney Erlinson asked us to do, we would do that on that same meeting. Am I understanding this right?
Yeah.
It'll be okay. I want to get
It would
clear.
give us some time
All right.
to have a better idea of what may be happening with representation for the subjects of the depositions. So that's important. We would have had a few more days to,
To read and look at the,
right, to think about the filings that we just received. I think we would still need at this meeting to decide whether we're going to call off the hearing that's scheduled for Friday. And we're not, but we're talking about waiting until next week to set a time for the adjourned hearing.
Yeah, if we want to do this in,
Did you file that motion, sorry, you moved to adjourn the hearing? Is that right?
Right, but we
You
didn't
did.
pick a date.
right.
we can still adjourn the meeting to a later date, right? We could do that.
Right.
We could say to a date no later than some particular date, I guess.
Might be good to put a qualifier on that, yeah.
I think we could do that. Attorney Larson?
I just want to be sure I understand what you mean. Are you saying that we will adjourn the hearing to a date no later than blank?
Yes,
Yes.
And then also hold a meeting after September 9th sometime
Yes,
for further procedural issues?
right.
Yes.
And to set an actual date for the hearing, I guess.
which we would do at the post-September 9th meeting,
Well, or decide what we're going to do about it, yeah.
correct?
Whether we actually have a date or not. Okay.
So I guess that's, the motion would be, I would alter the motion, which hasn't been seconded yet. I'll withdraw it and substitute a motion that we adjourn the hearing date to a date no later than, let's say the first Friday in October. And that, well, I guess that's all we need on that motion. And then we would have to deal with a motion for another meeting next week. And we also have to deal with the subpoenas that are already outstanding for people to appear on Friday. So anyway, my motion is to adjourn the hearing until a date no later than the first Friday in October.
It's October 3rd.
It's October 3rd, okay. Is there a second to that?
I would second that motion.
Moved and seconded. Do we have any further discussion on this?
So we're voting again, the motion is a two-piece motion, or is it, I want to make it clear in my head.
It's a single piece. It's,
Single piece at a time.
right, this motion is simply to adjourn the hearing that was scheduled for the 5th
Yeah,
to to a date no later than
October 3rd.
October 3rd.
Okay, that's it?
That's it. It's been moved and seconded.
Okay.
Attorney Erlinson has raised his hand.
Yeah, thank you. Yeah, I just wanted to note for the record that I have a trial the week of September 22nd and another trial the week of the 29th. And so, if by putting the 3rd as a backstop, that would jam me up pretty good. If we had it be the second Friday in October, I'll make it work. No problem.
Okay, I think we
So
want to.
if I might ask the
Okay.
chair to propose an amendment,
So
I would
that
really
means 10.
appreciate it.
Well, I will alter, if I've got a friendly amendment, we'll alter that to the
Right.
second Friday in October.
And actually, who seconded it, they have to,
I will, do I need to move to amend or just second
No,
the
just-
amendment?
I thought,
If you're agreeable to that amendment,
then it's,
then
Yep.
that's changed then.
okay.
Yes.
All right. Anything else anyone needs to bring up on the motion? All right, we'll call the matter to a vote. All those in favor signify by raising your hand.
Does it matter which hand?
It's unanimous. Doesn't matter. Doesn't,
Okay, 'cause
either
I'm-
hand will count.
I'm left-handed, so I can.
Glad you got them both. So, all right. Then we need to look at scheduling a meeting next week, probably Wednesday, Thursday, Friday. Anyone have conflicts that they can't escape during that time
Wednesday,
period?
I
Thursday,
cannot
what
do
dates are
Thursday.
those? Wednesday, Thursday, Friday, give me the actual dates. I might be able to remember.
10th, 11th, and 12th.
10th, 11th. Depends when, what time. For me, the problem is I did not bring my computer, and my cell phone no longer is reliable.
Okay, we'll do the best we
I'm in
can
a-
on
I'm in
that.
a, electronic failure. is
Robin,
what-
how about you? You're not retired.
Right, Robin would be more.
You have a preference.
I would have a preference. September 12th
Okay,
after 3:30. I don't know if that's a Friday on the 12th, if we could meet at 3:30 or so, or 4.
If we can push it to
Okay with
4,
me.
that would be better for me, but
pretty sure. Even
What's-
though my telephone lies to me.
Friday, the 12th
Friday the
at
12th.
4.
4
In the
p.m. works for
afternoon,
me
or-
if it works for you.
4 p.m. works for me.
Is that 4 p.m.? Okay.
Friday,
Tom,
September
is
12th.
the room available?
Yeah,
Yeah, Cody will let us know about that.
The room is available at that time.
What did he say?
And then we need to check with the attorneys.
Right. What was the time again?
4 p.m.
4 p.m. Okay. Gonna circle around that. Okay, that's
That works for me.
what. Mr. Yeah. Erlinson, does that work for?
I think he's checking his schedule now.
Okay. He gets to do that.
Attorney Erlinson, still looking?
I'm sorry. I know I was part of the conversation. The 12th is fine for me. I can make it work.
Okay.
I will
Great.
make it work.
Thank you. All right. So the proposal is, I guess I can make that motion too, is that the board meet at 4 p.m. Friday, September 12th, to discuss this issue again, discuss setting an actual date, and to hopefully deal with the motions that have been filed as well. So, is there a second to that motion?
So let me get this clear. We're voting on two things, right?
Well, I would,
Voting on a meeting,
Just the one.
scheduling
Right,
a
right.
meeting.
But I mean, it's scheduling the meeting, but I thought what
Well-
what the meeting is for.
well, I think the
would be on
chairman can come up with an agenda.
Right, we'll do that.
Okay.
We'll get an agenda.
We'll know more after we get the.
I would second that motion for a meeting on September 12th at 4.
Moved and seconded. Any discussion? Seeing none, all in favor signify by raising your hand.
Okay,
Motion passes unanimously.
okay. Terrific.
Great, thank you. And I think we need to deal with the issue of the outstanding subpoenas. Attorney Larson, have you got any advice for us on how to deal with that?
I'm sorry, can you repeat that?
If you could please advise the board on how we should handle the outstanding subpoenas for witnesses to attend the hearing on Friday. And obviously, if it's not going to be done on Friday, we need to do something about those outstanding subpoenas.
I think we should release those subpoenas. If we had new dates, we could issue new subpoenas, but we can't, you know,
Okay.
we don't have a new date yet, so we can't do that. I think we just send a notice to all of those folks that the subpoena has been released, and we will be
Okay.
notified of the new court date
So we make a motion on
when
that?
that's determined.
We don't have-
Thank you.
we can just release them? He can? He's got superpower? Okay, I mean, I'm
think that's,
glad.
is it more procedural? That's not something that we have to vote on, or is that something that we need to vote on?
Right, the same question.
Yeah, I mean, we've already decided
Well-
we're not going to have the hearing
Right.
on that date. But some kind of notice needs to be given to them And
All right, okay.
Attorney Larson, would you draft that and send it to Cody, and he can get it out to the witnesses?
Yep. Will do.
Right, thank you.
Thank you. Good, so we don't have to vote, all right.
Don't have to vote on that. The next item of the agenda is something I think we could discuss at the next meeting or maybe a future meeting. That's discussion and possible action on procedures for the hearing. And Attorney Larson and I have been doing some work on that already, but let's hold off on it till we get,
Right. And after we hear the motion to, or consider the motion to dismiss as well.
right. So does anyone else have anything to come before the board? Seeing not, I will entertain a motion to adjourn.
Okay.
Second.
You want to move? I'll second it, okay.
Okay, moved by Jesse Kearns, seconded by Doug Hostler. All in favor signify by saying aye.
Aye.
Aye, or raising your hand, or either or. Thank you very much. The meeting is adjourned. Thanks to the attorneys. Very helpful.
Thank you.
So we're not, September 5th, we don't come here.
Right.
And the next time I see you is
The 12th.
September 12th.
Right. Sounds good.
That's if I stay alive, you know. I'm always hoping. At my age,